Hi, I'm Gilbert Gonzalez, Vice President and General Counsel here at the San Antonio Board of Realtors.
And I'm Linda Drever, Member Care Director here at the San Antonio Board of Realtors.
And thanks for checking in on looking to learn about the new MLS rules changes.
So first we're going to start off with a topic overview and just discuss in general why these changes were taking place. If you've had a chance to look at the rules online, then you know that there's a lot of things that have been changed. Some of those were done as administrative changes as recommended by NAR. So those are not anything that SABOR initiated, but instead it was the National Association of Realtors that made those suggestions. The changes we're primarily going to talk about today are the changes that SABOR initiated and SABOR decided was in the best interest of the membership. These include scheduled listings, seller's authorization form and the 3-day submission rule for that form, the new fine structure with regard to late submission or sold data, and the last one would just be changes to the photo requirements regarding quantity and what should be included. All of this changes are the result of the MLS committee and a subcommittee working to change the policies and through multiple studies of the rules, and that's how we got to where we're at today. So the origination of the changes come from coming soon signs popping up in and around San Antonio. With this practice involves liability, and there was also member concerns. We had a lot of people calling us saying, what can be done? I was driving through this neighborhood and my consumers were in my car and they told me, why didn't you get me the information on that house? And those agents weren't in a position where they could answer and say, well, I don't have any info on that house. And we felt that agents were concerned, how can I look good in front of my client if I don't have all the available properties available in San Antonio? So we were addressing that concern as well. Also, with regards to coming soons and liability issues, there were some agents who expressed their concerns and said, hey, we need more than 3 days to put houses on the market. Photos take a little bit longer nowadays to get produced, whether it be painting needing to be done on the property, carpet steamed, stagers, any number of things. But 3 days was one of the concerns that agents were telling us they needed more time. So if you look at the liability issues, there's 4 common themes that are involved with regards to them. They entail breach of fiduciary duty, the Realtor Code of Ethics, and the MLS rules, and last is the antitrust issues and fair housing issues. So before we get into the liability issues, we want to talk a little bit about defining what a listing is. And more in particularly, how do you define coming soon, off-market, pocket listing, quiet listing, whisper listing? They all have different names and they all have different definitions for individuals. Mainly what we want to talk about is 2 very different situations. One in which the client motivated the request and one in which the agent motivated the request. Obviously, when we talk about a client out of their own volition asked to keep a listing off the market or off the MLS, that is something that is within their right, completely allowable, and a very legal request. What we really want to talk about is the idea that the off-market request originated as a result of the agent's persuasion. Not so much that the client requested it, but the agent said, it'll be to your advantage if we do one of these things, if we keep it in this strategy, if we approach this strategy, there will be a benefit to you. So that's really what we're talking about today. Not so much when the client requests the information, but when the agent is the reason for the change. So we're going to talk a little bit, start off with fiduciary duties. When we talk about fiduciary duties, we're talking about the first paragraph of our rules within the TREC rules. 531.1-1, the primary duty of the agent is to represent the best interest of the client. 531.1, number 3, agent places no personal interest above that of the agent's client. So when we were talking a second ago about whether or not the client requested the information or the agent requested the information, we say that how can you possibly make the recommendation that keeping something off the market is advantageous to a client? The TREC advisor recently put it this way: if you're going to convince 12 jurors that it's in the client's best interest to place a listing within the market of 100 people as opposed to 1,000 people, how is it more likely that that house will sell? How is it that the average consumer should expect a price to be
the best possible price if in fact you're marketing it to a limited number of people. And the reason why that's a concern is because it violates these two rules of who is the primary duty to. So when the agent is the one requesting that it take this type of status, the issue becomes, did the consumer fully consent? And if they did consent, were they aware of what they were getting into? And whose interest was it being taken care of when you put it forth this way? With regards to the Code of Ethics, which is on the next slide, we're talking about Article 1 and Article 3. Article 1, protect and promote the interests of your client, and Article 3, cooperate with the broker. They pretty much mirror those of the TREC rules. The only difference is the Code of Ethics is going to be a little bit different standard. So this is going to be an agent who calls and reports the conduct of another agent. So for example, we mentioned earlier that a consumer was in a car with a realtor member, they were driving in a neighborhood, and they were unable to provide them information about this one house. Let's take it a step further in that the agent did try and cooperate with that agent or get some information about this house, which was marketed as coming soon. And when they made contact with the listing agent, in fact, the listing agent wasn't cooperative or didn't provide them the information or told them the house was not going to be on the market for a extra number of days. When in fact, 2 days later it sold. Could an agent reasonably request a ethics hearing with regard to this conduct as saying that they weren't cooperative with each other? I believe they could. When we talk about MLS issues, we're talking about non-cooperation as well. We would say that it encourages buyers to deal directly with sellers' agents and cut buyers' agents out of the loop. So if that same consumer who's driving in that car decides, well, I'm not going to let my agent know, but I'm just going to call that number there directly and try and negotiate with them since my agent doesn't know, are we being cooperative with each other? Are we facilitating helping buyers and sellers? The other thing about the MLS rules, and this is one of the concerns that was brought up and that we addressed, is that all listings must be inputted into the MLS within 72 hours or 3 days. So all listings from the date they're obtained by an agent must be inputted within 72 hours or 3 days. Why this became a concern was why we mentioned earlier, which was given the current market, there was a need for more time, either to get photos, as we mentioned, carpet cleaning, or any number of things. So we took this into consideration as well when we were enacting the new rules. So if we move on to antitrust and fair housing issues, we're talking about those two things as they would apply more along the lines of to a pocket listing. So let's just say a home is marketed only to a select group of people, whether it be a neighborhood, a particular area of town, or whether it's only a limited number of brokerages or only one brokerage has access to this select group. Regardless of the conduct, whether it's intentional, it does not matter. If it can be proven that as a result of this conduct or as a result of this small group, that it discriminates against a protected class, we're talking about a fair housing issue. If anyone, again, regardless of the intent, can show that there was a protected group that was discriminated against or kept out, then you would be able to say there was a fair housing issue. Now, the other one is just antitrust. And this would be under the same scenario, only a limited number of agents have access to a listing or select individuals only. This creates an environment that diminishes cooperation and it reduces competition. So when we have an issue of reduced competition because a small group is being created, these are antitrust issues. It's not an issue so much that a group is created. What is important to remember is the conduct which the group undertakes. That's going to be the important factor to determine. Some of the other concerns were just the legitimate need for more time, which we've talked about, contractual issue with regards to commencement date versus marketing date, and I'll get into that in just a second. Preventing agents from losing listings, obviously a concern, and a lot of people were concerned about whether or not the clock on their listings would immediately be initiated once they inputted it into the system. For whatever reason, there is a stigma amongst sellers or buyers that the number of days, if it's excessive, it makes it seem like the property has something wrong. So I mentioned it earlier. In our listing agreement, there are two terms that have often been confused. They involve commencement versus marketing date. When I talk about commencement, we're talking about paragraph 4. The paragraph is titled Term, and it says in summary, the listing begins on blank date and ends on blank date. When we talk about term, we're talking about when this agreement comes into effect. So, if today is the day I visit with my client and I put into the term, this listing begins on 30 days from now, my legal obligation to this client does not begin until that day. On the same token, the obligation of the client to me does not begin on that same day. So if we were to delay or approach the situation as saying, oh, well, you need more time to get something done, and you in fact put a date with regards to paragraph 4 term that is 30 days out, you have no legal obligation to this client, nor do they have an obligation to you. To market a property during this process would be unwise, because if it's sold, there isn't necessarily anything that commits that client to you. What I think was being done was an attempt to use paragraph 6, listing services. Seller instructs broker not to file this listing until blank date. And before this change, it used to be where you would be able to delay it in this paragraph, and you would be able to accomplish that same goal of delaying something for a limited number of time if you use paragraph 6. But as you notice at the very bottom of paragraph 6, it says, do not use this provision if prohibited by the MLS. Prior to these changes, the MLS did not allow for anything past 3 days. Now, given that the listings have gone to this new status of scheduled, you will be able to use paragraph 6 to delay a listing from being marketed for up to 14 days. So again, paragraph 4, term, talks about the effective date of this listing taking effect, in which the obligations between both parties begins to each other, and paragraph 6 talked about when you would be able to start marketing the property. The listing had already begun, but paragraph 6 applied when would it effectively been marketed and how. So now we're going to talk about implementation. We have all these concerns and we had all this information from our subcommittee. What ultimately became a new status was the scheduled listing status. What it provides for is that an agent now may delay the listing up to 14 days before a home is distributed outside the MLS. So you can put a listing into the MLS, put it in as scheduled, and what it will not do is send it out through all the different portals. It won't be sent out through any IDX feeds, and it won't be searchable under traditional search criteria. If you also put this home on a scheduled status, it stops the days on market clock from ticking, and limited listing data will be made available only to the members. So if an agent is interested in finding out what homes are currently in scheduled status, they would be able to find that information, but it's only going to be limited information. It's going to be the brokerage, who's the listing agent, and the day on which the listing intends to go from scheduled to new. In order to use this scheduled listing status, however, we did create a requirement that a submission of the seller's authorization form be included with all listings before it is being taken advantage, or before you get to use this status. So, if we talk about the updated seller's authorization form, what we had prior to today was a 1-paragraph form that involved just a disclosure of, we go ahead and keep this listing off the market. What we now have is a more extensive document that details the different advantages and disadvantages of keeping a house off the market, and it provides greater protection to agents so that they can say a consumer was fully aware that of the consequences of using one of these statuses. These seller's authorization forms were not previously required, but now they are being required to be submitted for all off-market listings, so those that are just completely going to stay outside the MLS, as well as anything that is scheduled listing. If either one of these options are used, the seller's authorization form must be submitted within 3 days or 72 hours from the date the listing is scheduled. In the event that the form is not submitted within that 72-hour time frame, we now have a new fine structure as well with regards to that, and that will be a new fine of $500 for failing to submit that form. Last, before I turn this over to Linda regarding the steps for the rules changes, I want to talk about two other changes that were done. One was prior to the rules changes, only one photo was required for every listing, and now 4 photos are required for every listing being put into the MLS. And the other is there was a $5,000 fine previously for any listing that did not report the sales price information to the MLS, and that has been increased up to $10,000.
Any property listed is bound by the MLS rules and regulations. MLS rules and regulations state that a listing must be entered in the MLS within 72 hours of the execution date of the agreement. A new status of scheduled SCHD is now available. The purpose of this status is to allow the seller up to 14 days from the execution date of the agreement to prepare the listing for sale. These are the steps that should be followed. 1, the seller's authorization to exclude the listing from multiple listing service must be signed by the seller, the listing broker, and the agent. Once completed, follow the steps below. Go to My Listings, My Transactions, as you would normally to add a listing. Under the Office Sales tab, respond why if you have a signed authorization. Continue on and save the listing. Upload the seller's authorization as an additional document. Complete instructions are available in the MLS. The listing will automatically move to a status of new at midnight on the 14th day or before, contingent on the number of days that you entered. Scheduled listings will be available in a one-line report to all MLS participants and subscribers. In the event the seller checks B on the authorization, the listing is to be held from MLS permanently. Send the completed and signed seller's authorization to exclude listings from the MLS to support@sabor.com. Failure to submit the form could result in a $500 fine. Thank you for watching, and as you move forward, if you have questions, please email me, Linda@sabor.com, or you can email support@sabor.com.
And if you have any questions for me, you can reach me at Gilbert, Gilbert, @sabor.com.